Hi there, welcome to the video lecture for Chapter 11, which focuses on circumstantial evidence. So we're pivoting back away from criminal procedure back into the concepts and foundations of evidence. Direct and circumstantial evidence is defined in a federal jury instruction as the law makes and to let jurors know, the law makes no distinction between the weight or value to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial than of direct evidence. And this is the majority rule across the country. There are a couple of other states, 13 states, that tell jury members they cannot find a defendant guilty based on circumstantial evidence unless the circumstantial evidence cannot be reconciled with any other rational conclusion or it's consistent with the theory that the defendant committed the crime. But again, that's the minority rule. So when we're talking about direct evidence, that is the testimony of a person who asserts or claims to have an actual knowledge of a fact. So an example here would be an eyewitness. Circumstantial evidence is evidence that tends to prove and establish the facts in dispute by proving the existence of another set of facts for which an inference or presumption can be drawn. So at times this might be the testimony of the law enforcement officer who responded to the event. They oftentimes did not observe the event in that circumstance when they were responding to the call. And so their testimony is going to provide another set of facts from which a conclusion can be drawn, such as they responded to a crime and they observed the person who called with a bruise on their face. So somebody, and based on the call and the circumstances, somebody put the bruise there. So that's another set of facts. I responded to the call. I observed the witness with a bruise, and a conclusion can be drawn from that the other person in a home or in the apartment is the one who gave the victim the bruise, right? So just a fairly simple distinction between how these work. Sometimes circumstantial evidence is called indirect evidence. I prefer to just call it circumstantial. I think it makes it more clear. So if direct evidence is the testimony of someone who claims that they have actual knowledge of a fact, why would we use circumstantial evidence? Circumstantial evidence, for one thing, can often be as convincing as direct evidence in proving guilt, or even sometimes is more reliable. For instance, scientific evidence by a forensic expert is circumstantial evidence. They are the person who ran the drugs through the lab, the person who did the DNA, the person who did the fingerprints. That's circumstantial. It's based on another set of facts that the DNA matches the DNA found at the crime scene. But that's very reliable and sometimes even more convincing to the jury than an eyewitness testimony. And we use circumstantial evidence because it just fits in with human nature and the way our brains work and process things. Our experience teaches us that when we have the same set of circumstances occur over and over again, the result is likely the same. Further, as circumstantial evidence is perfectly acceptable to use, and it has to meet the same standards for admissibility like direct evidence. It needs to be relevant, and it still has to be presented from a witness who has personal knowledge about the topic of their testimony. And if there are questions about the validity of evidence, remember, during the pretrial process, motion in limine can be filed to keep out the testimony of a witness or the piece of tangible evidence. And even during the trial, either side can object depending on how it's presented. If it's not, if the foundation hasn't been laid, if it is being used in a way that's more prejudicial than probative, things like that. And again, the judge is going to use the balancing test we've been talking about off and on all semester. Is the probative value substantially outweighed by the danger of unfair prejudice, confusing an issue, misleading the jury, undue delay, waste of time, or the needless presentation of cumulative evidence? Okay. Circumstantial evidence can be used in a lot of different ways in criminal trials. I like this example from the slides. If someone's on trial for burglary, all of the evidence presented by the prosecutor might be nothing more than a series of events from which the jury could draw inference of guilt. If this were the case, none of the facts individually or even collectively will directly prove that the burglar, the accused is the burglar. But as a whole, they're going to be as strong at establishing guilt beyond a reasonable doubt as if there was an eyewitness who could testify to the event. One of the most common uses of circumstantial evidence in criminal trials is to connect the accused with the crime. To establish identity of the accused, prosecutor may introduce evidence that the accused has engaged in similar crimes in the past, or sometimes there's just not an eyewitness or someone with direct evidence that can place someone at a crime scene, but somebody can be called to talk about the last time they saw them and how close it was. Somebody can, so there are ways to put someone at the scene of a crime. Now, for the slide where we're presenting evidence of modus operandi, revealing to the juror that this defendant has committed other acts of wrongdoing can be problematic. It can be prejudicial. So the common law developed, and the Federal Rules of Evidence stands by that evidence of past misconduct and crimes are not cannot be introduced unless they're extremely reliable. And this makes sense. If the defendant is not on trial for those actions, we do not want to create a presumption that, again, this is a horrible person, therefore we should just convict them on whatever we can, because that's not how our constitutional framework works. Usually, and oftentimes in the cases I've worked in my prior career, when a prosecutor was planning to do this, they would file, motions would be filed, so the judge this would be known to everyone in advance that the past similar misconduct, the modus operandi, was going to be used to help confirm identity in the case. All right, character evidence. Under Federal Rule of Evidence 404A, the general rule is that evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with that character or that trait. Again, we need to prove that they engaged in the action this time. So evidence can be introduced if it's of past wrongdoings, of bad character, if it's pertinent to a trial issue, so if it matters for this issue that the defendant had bad character, or if the judge believes the evidence is particularly necessary to assist the jury in arriving at the truth. Other crimes can be used to create or establish circumstantial evidence of guilt when offered on issues such as motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. If we think about it, when we watch those crime TV shows, we'll see this kind of in work. They will show, well, it has this person, we want to present this because we don't want the defendant to claim they didn't know how to commit this crime, when we know for sure that they've committed similar crimes in the past. So it's not to say this defendant's a bad person, it's to say this defendant absolutely has the knowledge or the skill necessary to perpetrate this crime because we can establish they've done it before. Other acts, past misconduct, things that, and when we're saying misconduct here, we mean things that you have done that are bad but that you were not convicted of. Past crimes often get used in criminal trials to establish motive, the reason why you acted the way you did. Motive evidence is almost always relevant to the accused's conduct, identity, or intent. And again, intent is the state of mind, motive is the reason why, if we think back to criminal law. Intent is a necessary element in most crimes, especially the crimes that make it to trial. Mens rea does need to be proven, and so showing that this person had the intent to do this because they have done this same behavior in the past can be a very effective way of convincing the jury that this person did have the intent on this day and time in question. They knew and understood the consequences of their actions because they have done the same behavior before. When other crimes are offered to prove plan, you can use those past crimes to show this person created a plan or that they had a design. Prior acts are evidence of a common plan or design. It's not used to prove the intent, but that the defendant themselves engaged in the conduct here. So I think an example that gets familiar are like serial killers who take a trophy or leave behind like the calling card. That would be an example of a plan or design of ability to tie multiple victims to the same perpetrator, the same murderer, because they left the crime scene the exact same way, or they left the same markings behind every single time, or they cut off the defendant's finger, whatever it may be. So that is one example. I have also seen this used though with like driving under influence cases and things in the past. So not just for serious crimes, for any criminal offense where planning is an element. The doctrine of chances is the use of other evidence of similar occurrences to show that this was not an isolated event due to chance. So this is often another way of showing that this cannot have possibly been an accident because of these other similar occurrences. And again, we think circumstantial evidence in general is often designed to get at this type of events where we don't have a piece of direct evidence, and so circumstantial evidence is just really effective here, and it's permissible as well. So during criminal cases, again, not only must the fact that the crime occurred happen, but it must be established by a prosecutor that this is the person who committed the crime. So identity is always relevant. And so this will always need to be established unless the defendant is raising an excuse or justification, because in that case, identity is no longer an issue. The defendant is admitting to the conduct, but they're just saying that it's excused or justified. So in every case except for those circumstances, this is an element. Now, means or capability. Circumstantial evidence is often used to show that this person had the means with which to commit a crime. So if we think maybe about a crime of violence, anytime the person had before engaged in smaller acts of violence, or maybe even something similar like cruelty to an animal, that may be relevant to show that this defendant had the means and the capability to engage in acts of violence. So it should not be a surprise to us that they continue to perpetrate violence. Past acts can also be used to show that there's consciousness of guilt. Proof of an uncustomary act or statement or appearance can be used to show that you are aware of your guilt, of your responsibility for your behavior. Evidence of guilt. So these are all reasons. So we spent a bit of time talking about all the ways that your consistent behavior can reaffirm itself and potentially be used in a criminal court. These are things that are usually not the way that you would typically behave, but also can show consciousness of guilt and evidence of guilt. Fleeing the scene, a highly emotional state after committing a homicide, attempting to evade and escape an arrest, denying your identity, using a fake name, failing to come back for trial, concealing evidence, refusing to participate in a lineup, refusing to participate, furnish handwriting samples, attempting to bribe somebody. If the defendant has a reputation for bad character, this can also, again, be another time for circumstantial evidence. The prosecutor cannot introduce evidence to show the defendant is a bad person to prove guilt, but they can show that this person has bad character, has poor reputation, if it is pertinent to the issue. Proving good, this kind of further explains why we don't let character evidence in all the time. Proving the good character of the defendant can happen in opposition to a crime. Here, the character is your attributes and your traits, and people who have opinion can come in to testify. If the defendant introduces their good character, the prosecutor can impeach this by introducing evidence of their bad character. So this does open the door to the possibility that the prosecutor can provide witnesses that say, well, that's not true. My experience is this person is not a good person. All right. I'm going to pause the video here and take a break, and we